Hi, this is Kurt Barone, and welcome to another edition of File Law Vlog. Today, we're going to go over a case that was just handed down by the Fourth Circuit U.S. Court of Appeals um, on an important topic. And I've got my colleague, Bill Macarone, who's really been covering this particular aspect of the Fair Labor Standards Act for almost 6 years now. We do a 24-hour class on the Fair Labor Standards Act, and we kind of divide the material up. And this is one of Bill's areas. So, and I don't think there's anybody out there that's got the knowledge and the sort of the sense for what's going on that Bill has. So, Bill, welcome. First of all, welcome.
Well, thank you. Thank you for having me, and thank you for that introduction.
Yeah, no, and all right. Well, tough case for some, and it'll be a good case for others. So I guess it depends on your perspective. But let's get right to the issue. Go ahead.
Yeah, absolutely.
Tell us about what happened.
The issue is overtime. Go figure. But that's the primary issue is overtime and whether or not you can classify firefighters. So when I say firefighters, I don't mean like a firefighter first class or an engineer, but more of a senior officer, whether it's a captain, whether it's a battalion chief, a shift commander, whether you can classify them as overtime exempt employees. And the exemptions that exist and the exemptions that those folks are typically placed under or in are they call the white collar overtime exemptions. And you have an executive, administrative, professional employee, and a highly compensated employee. So the FLSA contains several of these exemptions that I just described. And the challenge for many employers is to try to say, listen, do my senior level firefighters, do my shift commanders, the officers, the chief officers, can they meet the definition of a white collar overtime exempt executive employee? And then on a lesser scale, or not as common of an issue, but certainly an issue, and what we're going to draw a comparison to today, how about your senior folks that are assigned to the trucks? You got a captain that's a senior officer, and they're actually assigned to an engine or a ladder company working a 24-hour shift, et cetera. So this has been a hot topic in the fire service, and I'm going to say for the entire time that I've been really doing this deep dive.
Well, certainly it goes back to
area.
1985, right? I know we're not going to be. We have the 3-day class. Actually, it's 4 days now that we do it online. And live, it was 3 days, but the web version we do 4 days because we go a little bit shorter each day. But we go through a lot of the background information, and the FLSA became applicable to fire departments in 1985. So prior to 1985, whatever you were doing, you could get away with it.
Not an issue. Yeah.
After 1985, the world changed, and some of the principles that applied to private industry about managers and executives and people work in offices that can come in late and leave early, but you got to stay late also when necessary. Those that kind of go along with being executive got applied in the public sector. And that we saw a lot of cases in the late 80s, early 90s about that up until I believe it was 2004.
The first responder regulations. Yeah, that was 2004. Yep.
2004 is when the Department of Labor, there were so many cases, some saying like a lieutenant was an exempt executive, some saying a deputy chief was not. The cases were all over the map. So the Department of Labor came out in 2004 and again, because I mean, I know this stuff a little bit, but this is really your area of concentration. So
yeah, well, you're absolutely correct. The cases were all over the place. So in 2004, the Department of Labor came out with a new regulation, and it's commonly referred to as the first responder regulations. And basically what those regulations were intended to do, or what the intent behind those regulations was to kind of put to bed all of these cases all over the place. You had, like you said, lieutenants being treated as executives, but yet you had high level chiefs possibly being treated as hourly. So it was both sides there that the Department of Labor was looking to more or less to kind of solidify, in a nutshell, who's entitled to overtime. And that's pretty much it. Who can be classified as a white collar employee and who cannot be. And by the title, as you can imagine, they called it the first responder regulations. The DOL came out with this rule that said that if you're a first responder, if you, if you're, and we'll talk about this in a second, but if your primary duty or the most important function that you perform for your employer is responding to calls for fire, controlling fire, extinguishing fire, rescuing victims, etc., you just can't be considered a white collar exempt employee. So if that's your primary duty, is performing these types of roles within the organization, responding to calls, getting dispatched to calls, working a 24-hour shift. These are all the factors that kind of go towards determining that primary duty. Basically, the Department of Labor said, listen, if your primary duty is acting as a first responder, you cannot be considered an exempt employee under those white collar overtime exemptions. And now, ever since '04, we've seen a new line of cases, so to speak, where now courts are starting to really look at the language that was used, and they're looking at the preamble of the language, and they're looking at the congressional, and they're looking at the debate that was undertaken by Congress back in 1985, really just trying to justify each other's, their arguments to come up with ways to slice and dice this to try to see who fits and who doesn't. And unfortunately, if you're a shift commander, and I say shift commander, like a battalion chief or whoever in your organization, when some of them have deputy chiefs, division chiefs, et cetera. But if you're a shift
some
commander,
have captains, so that's another lot of
and some have captains
departments
are in charge.
Yeah,
absolutely. Yeah. So that's if you are a shift commander and you're commanding the shift. Unfortunately, if you want overtime or you receive overtime now, the Fourth Circuit kind of dealt you a little bit of a blow. If you're an last week, if you're an employer, you might look at this as, oh, wow, this is a potential opportunity for me to, trim off of my overtime budget. So I think what we'll do is we'll just kind of briefly touch upon a little bit of a description of what an EAP employee is, just a couple minutes, and then we'll look at the decision from last week, and then we'll look at a similar decision that was reached in the Fourth Circuit, same area, same region back in 2016, where the court came up with an opposite result. And I think it makes sense to kind of look at the rationale for both of those. And it really helps us to at least see, if nothing else, the way the Fourth Circuit is most likely going to be viewing this going forward. And I do think other circuits are going to follow suit. I think that's just the way, maybe not unanimously across the country,
the 11th,
but I do think it's going to be, well, the 11th, we'll talk about that later. If you want to know about the ins and outs of the 11th, we need all day here. We don't have, can't do that in 30 minutes or so.
Okay.
So what we're talking about is the EAP exemptions, the executive, administrative, and professional employee exemptions. And also there's a small exemption that's attached to that called the highly compensated employee exemption. And it's relevant because it's brought up in both cases where the both those cases, the city and the county argued that the folks were exempt under that as well. But basically, in a nutshell, in order to be considered a white collar overtime exempt employee, there's a couple of boxes you have to check more or less. Number one, you have to be paid a salary, and that salary has to be a minimum amount. Thankfully, in terms of everyone involved here in the Fourth Circuit that we've seen, the salary is not an issue. It's only about $600 and change a week. That's really not an issue for the most part. These folks are all making good salaries. Obviously that's I don't know if everyone would agree with that, but they're certainly their salaries are good salaries at the end of the year. That's the first component. The second component is you actually kind of have to look to say what is their role within the organization and what is their primary duty. And essentially their primary duty is what the Department of Labor tells you is the most important function or the most important thing that person does for the employer. And you have to make sure that primary duty is management for the executive exemption, which is what's going to pretty much carry the day here. We're going to talk about the most. Your primary duty must be management of the organization. And now think of that, because now we're talking about responding to emergency calls. So you're going to kind of start to ask yourself, is the shift commander's primary duty, the most important thing they do during their shift, is it managing the fire department, or is it going to calls and responding to incidents? And that's where the line is drawn, and that's where we're starting to see this get really, I think that's a good way to put it, slice and dice. You're really boiling this down to the minutia, the little things that make a difference, and you more or less you're starting to get to see the way that the courts are approaching this. So the first case we'll talk about, and it was the case that was handed down just last week, and it's Emmons versus the city of Chesapeake, Virginia. And Emmons was a case that was filed in, I've got notes here, July of 2018 was when there was seven battalion chiefs down there in Chesapeake filed a lawsuit looking for overtime. They were being treated as overtime exempt employees. And it's very common in these circumstances that the city just treats you as overtime exempt. They don't necessarily identify what the exemption is. So that when this goes to court, they pretty much, the attorneys doing their job just the way I think Kurt and I would do if we were representing the city. You throw everything out there and you just, hope that something sticks as far as the different exemptions. So in a nutshell, they were being classified as white collar overtime exempt executive employees, and also highly compensated because they all made right around $100,000 a year, which is the threshold for that requirement or that exemption. So in the end, the battalion chiefs took their arguments forward, filed a complaint. Their attorneys filed a complaint. The defense filed an answer, and went back and forth. Well, before they went to trial, it was a little bit interesting happened is that the judge basically preemptively just kind of on a ruling, because in these decisions, in these cases, it's very common for the plaintiffs and the defendants to file motions to kind of get their case decided without having to go to trial. You file a motion to say, listen, it's called summary judgment. You want your case decided on the undisputed facts. Here are the facts that everybody agrees with, and I'm entitled to overtime. And the city's going to turn around and say, here are the facts that everybody agrees with, and they're not entitled to overtime. And you hope that the judge kind of jumps in. And in that instance, the judge did. And the judge basically said, looked at it and said, no, these battalion chiefs, they're not first responders. They are in fact exempt employees. And they started to look at the different factors that the city basically presented, and the firefighters or the battalion chiefs, I guess, their attorneys, the factors that they presented. And you look at the both sides, and the judge ruled as a matter of law, that's what they call it, that no, these folks are overtime exempt individuals, and therefore there's no overtime. So why is this a big case? Well, these folks are assigned to a 24-hour shift, and these are some of the factors that the chiefs argued why they should be getting overtime, and it was pretty evident. They were assigned to 24-hour shifts. They had to basically respond when they were dispatched. They were dispatched regularly. They're on a run card. They're going on calls regularly. They operated under a very rigid set of rules and regulations and policies. So they really didn't manage the organization. They weren't really exercising discretion. That's another key term that's within that executive exemption. You have to exercise discretion with matters of significance. The chiefs were arguing, all we do is follow policy. And at the end of the day, the city was arguing the opposite of all these points. Well, yes, they're assigned to a 24-hour shift, but the main reason why they're on a 24-hour shift is to maintain what the court ended up, basically agreeing with the city on was they're maintaining the readiness of the battalion. Their job being there is strictly to manage the battalion as far as all the firefighters, to make sure that they were ready to go out and actually fight the fire if necessary. And that's where, and obviously as a firefighter, I think Kurt as a firefighter might agree with me. I don't want to put words in Kurt's mouth here, but they kind of drew a line and said, and the court came right out, and I made a note of it because I kind of was a little bit surprised by that, to say that the only way your first responder regulations only apply for frontline firefighting operations. And in that decision, the judge said that the battalion chief was more of a conductor of an orchestra. And that was an actual, that they're just conducting an orchestra. And I think that the judges seem to think, at least the judges in this case seem to think, that the battalion chief stands in front of the building and just kind of, is that what a conductor does? You wave the little things that they wave to tell, who to do what. And that's really what they, at the end of the day, that's the tact that the court took on this. And there were a number of factors that were presented by both sides. And we can go through them briefly because I don't want to kill it here, but it's surprising to see some of the factors that the court grabbed onto and found that was compelling. And probably what is a little bit disconcerting is these questions are typically presented to a jury. And that's typically
I find that troubling.
What you have here. I think that, and looking at this, and we'll look at the captains next, when you look at a battalion chief, and the battalion chief basically is truly a manager. I think that's a fair assumption to say that they are a manager. They are managing that, but the question becomes, they're managing that battalion. I think that's a fair statement. But the question becomes, at what point are they managing the battalion? And at which point are they running a fire scene? Are they actively, and I believe that by your actions as the shift commander, you are suppressing that fire. And what the court seems to draw a line is that if you're not actually, and they say it in the decision, if you're not actually handling a hose, then you're not a first responder.
That's what I've been
And
saying all along. The
and
ladder guys, right?
well, no, but you bring up a very good, and now think of this. If you have a heavy, and this is obviously, going to take it to an extreme, but you have a heavy rescue in your department. That heavy rescue, every fire, your policy is they go to the RIT function. They go to the RIT function. They set up in front of the building RIT. Are they covered? It's
Yeah,
crazy in my
yeah,
mind when you draw these types of distinctions.
yeah. Some of
And
the arguments that lawyers will make, and here's some of the problems. And I wish there was a court system with a judge that was a firefighter and a jury that was firefighters. There's no pulling the wool over people's eyes when it comes to what's going on. Then I think we're on a level playing field. But you've got attorneys on both sides that aren't firefighters arguing in front of a judge that isn't a firefighter, and they don't have a clue, and they're probably all thinking about, oh boy, what am I going to do when today's over? I got to cut my lawn, or I got to go Christmas shopping, or whatever it is. And do they really grasp what's going on?
no, and it's true. And the irony is the same circuit in 2016 came to an opposite result. In the same, when I say same circuit, this is a
Right.
circuit
So
court opinion.
Fourth
So
Circuit.
Fourth Circuit, it's the Virginia, I think North Carolina is in it, and it's the states right around the Mid-Atlantic region there. And basically that back in 2014, I believe it was, there was a fire captains in Fairfax County, fire in Virginia, were treated as overtime exempt. Now these are fire captains assigned to apparatus, assigned to a 24-hour shift. They're one step above a lieutenant because they are not only in charge of their truck when they're on duty, but they're also in charge of the station. So that's an added, there's no way to get around that. That's an added degree of managerial responsibility. However, in that decision, the lower court judge said, no, you're exempt executives to the captains. They said, no overtime, you're exempt executives because you manage the stations, you manage your company when you're out on calls, and you are a higher level manager. Well, the Fourth Circuit basically took that into consideration and reversed that lower court. And that's just a couple of years ago. So the Fourth Circuit turned around and looked at the factors they looked at in that instance, I should say, the folks in the captains participated in the same activities as lieutenants and to a lesser extent firefighters, who are clearly, the court said, is clearly eligible for overtime. Those positions, a firefighter, a lieutenant, that's on a truck. And again, you have to take the job titles out of it. It makes it difficult sometimes because as firefighters, you correlate who's in what position and who's where.
Right.
Under the FLSA, there are no job titles. You could, in theory, have a firefighter who just happens to be the firefighter who's in charge and be an exempt executive if such a place existed. So you have to take the titles out of it. But when I mention a lieutenant, I mention a captain, I'm talking about the traditional lieutenant that's on that
Company,
that
what we call company
officer. Absolutely.
Right.
So you're assigned a 24-hour shift. One of the key, and this is where it kind of got a little dicey when you look at the two cases. One of the key differences in the first decision with the captains and the second one was that the court made a reference that no matter what duty the captain was performing at the time of an alarm, once the alarm hits, they drop that duty. They could be in the middle of something managerial related in the station, putting up a new notice or something, station-wide notice. Call comes in, they drop that, jump on the truck and go to the call.
Just like a battalion chief would, right?
And the difference there though is the attorneys representing the battalion chiefs in this most recent case in the Emmons decision brought that issue up. And the court was able to point to one statement made by one, and if you can't tell, I spent the last 2 days diving through
we live a sad life, don't we? I mean, I do the same
no.
thing. It's sad, but
but they pointed to a deposition where one battalion chief who had been a battalion chief since 2007, so at least 12 years from the point of the deposition, there was one time that he stated, I believe it was a male, but he stated that he was in a meeting with higher ups when he got dispatched to a call, and one of the higher ups and one of the chiefs that was in the room said, hold off on going to that. We want you to finish what you're doing here. And he did not get disciplined for that. And that was acceptable. And the court said that that meant that he or she, they had discretion when to respond because of that one incident.
Well, I thought it
Now,
was their boss that told them not to
it
go.
was, it
Well, that's
was, but,
how is that
and this is,
yeah.
and the other thing too is that's a one-time occurrence over 12 years. I don't think there's undoubtedly fire chiefs are the vast majority of fire chiefs are going to be exempt. I mean,
Mm.
just the vast,
Yeah,
vast
yeah,
majority.
and that makes sense. And a lot of staff
And
chiefs are going to be exempt,
and that was my next line. The
Yeah.
vast majority of staff chiefs. Now, if a staff chief is driving down the road, going to a meeting, going to lunch, doing whatever, and sees smoke coming out of a house, you know what that staff chief's going to do.
Mhm.
And that staff chief's going to pull over, might even try to go inside to see if anybody's there. You know, if they got if they got a CBA on their car, they're going to throw one on. They're going to go in there and see who's in that building. I don't think that automatically makes them a fire, an overtime
Right,
eligible firefighter by doing that.
right,
That's
right.
just something. It happens
That's
if they're
not their
doing that
primary
every day.
responsibility. I think we get back
Exactly.
to primary responsibility.
And if they're doing that every day, then that's a different issue.
Well,
But
I do want to, because I've been, and I'm sure you've been probably inundated more than I have with folks reaching out to you about this ruling, and I've had a lot. And one of the things that, we try to emphasize this in the class, and we use a little metaphor in the class. We call it the close play at second base. And it's, I'm an old baseball player, and I use that metaphor a lot. But I think it's important in this that we don't overstate the decision. We don't understate the decision. We don't overstate it. And what I mean is, when you have a runner slide into second base, runner's stealing first. It's the first inning of a game. He's on first base. He's stealing second base, and he's thrown out at second base. That doesn't mean that the same runner, the next time they're running, is going to be out. Doesn't mean that everybody on their team, when they try to steal, is going to be out. Everybody on that field, both teams, is going to be out when they try to steal. It just means in this particular case, and sometimes as firefighters, we tend to look at a play. We don't understand maybe the rules that courts and state legislatures and everyone else is operating under, and we see a close play, and we see a person with a white uniform on slides into second base and they're out, and then we assume anybody with a white uniform that slides into second base must be out, and that's not necessarily what was being said here. Um, and just because in this case we have a ruling, and just because Morrison, in the earlier case went a certain way, we're looking at specific facts, and certain circumstances. So we don't want to overstate it, but certainly these are really important. They're almost like milestones in terms of the development of the FLSA law as it applies to firefighters. They're
I
certainly important, landmark
I
decisions.
agree.
But to say that because the battalion chiefs in Chesapeake are exempt executives, everyone is, not necessarily. Okay, Morrison, the same thing on company officers. There's a lot of factual issues involved, but seems like we have an emerging sort of a trend between those two.
I agree, and I agree with 80% of what you just said. I
Okay,
do take
cool,
what
good.
no, but there's an aspect of it that if the jury reached this conclusion, I agree 100% with what you said,
Right.
because every situation is different, and there's that close play at second base. You need to look at
Mhm,
all the different factors. The
mhm.
fact that the judge reached the decision without a trial, and then the circuit court kind of rubber stamped it or approved it, looked at it, and said, no, absolutely, that's fine that you did that. That's, to me, that's a difficult trend for me to swallow, not because
Mhm,
it's going that direction, but
mhm.
because the decision was made in that way.
Well, right, but
And
it's
that's
it is
to,
it's based on the facts of that
yep,
particular case, and not even all the facts, because there was some of the facts that you could argue that one of the things that stood out to me, and I skimmed the case, I didn't fully read it,
yeah,
but it talked about battalion chiefs only respond to 10% of the runs. What the hell kind of
yeah,
number is that? I mean,
yeah.
10% of the runs, so that means that somebody in a slow company, that company only goes to 2% of the runs. I mean, that's somehow significant to whether or not their primary job, it,
Yeah.
you know, so again, I think that we have to understand, there's certain things like the rules of baseball where each team gets 3 outs, you get 3 strikes, you're going to play 9 innings, and those things are where the judges should be, limiting their discretion. Other things, are really the close play at second base where the umpire should be making the call. And I agree with you. I mean, some of those calls, the application of the facts to the law should be made by the jury. Um, you agree on all the facts, but you don't agree on the application of the facts to the law. So, but again, be that as it may, based on the facts, the judge concluded there was no reasonable jury could conclude otherwise. Does that mean that everybody in a white uniform now,
No,
coast to
no,
coast,
and
is
I can.
automatically out? No, not necessarily. There's a lot of variance from department to
Yeah.
department in terms of what a battalion chief or shift commander does.
Yeah, and there's a laundry list of items that are contained within that executive exemption,
Yeah.
and the highly compensated really kind of dovetails into it as well. There's a laundry list of items, and really what you do, and not one item or factor is going to be controlling. Once you meet that salary aspect of it, now the rest of it becomes two baskets,
Hmm.
and you just pile factors in one side and pile the other factors that support, the factors that support overtime in one basket, the factors that support exempt in the other, and you truly weigh out the two sides. And there's no doubt, and especially in my experience and what I've done in clients I've represented, and certainly consulting I've done, it makes sense. A smaller department that has battalion chiefs that are involved in budgeting processes, that are involved
Yep.
in procurement. We're doing some renovations to a couple of the stations, and I'm putting Battalion Chief Jones in charge of that project on his days off. You're going to come back and manage that project. These are all high level management type things. And there's no doubt that there are battalion chiefs out there, shift commanders out there that would meet the exemption, even with being on that 24-hour shift.
Right.
I think, and it does depend on the facts heavily. But then there's also other ones that are in, especially, and I think it's more in tune to your larger organizations where you have this bigger hierarchy, and the chiefs now are no longer really in that senior management position. The shift commander is no longer in that senior management position. They are more, I don't want to say the word under the thumb, because that sounds like, it sounds almost like you're being pressured, but you're under the supervision of your administrative chiefs that are in there Monday through Friday, and you're really just truly running that, that shift to an extent, and you are dropping everything at the drop of a hat to go out the door and respond to a call. So I do think that it's an emerging area. I think that is truly there's a lot happening in this area. I think this is going to have some significant, I don't know if it's going to cause litigation to tick up a little bit. I don't know if it's going to cause litigation to taper off a little bit. It's definitely going to have implications, I think, and especially in the region, if nothing else.
Yeah, it may cause departments that are like you mentioned before, looking to save some money, um, to move in that direction, which then in turn can cause litigation. So,
Yeah,
it may prevent litigation in some situations, but to the extent that it causes departments to maybe change the way and stop paying overtime, and
yeah,
now that in turn could cause litigation. So trying to predict that could be, a little bit difficult to pin
difficult.
down. So
Yeah, and there's
yeah.
and
No, no,
go ahead.
I'm just thinking that, how it's all evolved from when I started looking at this. I graduated from law school in '85, and I kind of was watching as a firefighter who was, yeah, certainly a lot of us back then, and I'm sure now, just really living off of the overtime, and you pay your bills with the your regular wages, and you're living off the
Yeah,
overtime, and not doing like my law practice, and balancing overtime in my law practice was a little bit difficult, but overtime was important. And I know I've been following this closely since '85, and it seems like, this is a step toward greater clarity, and especially when you compare it to Morrison,
yeah,
Morrison being the captains.
yeah,
It is a step toward clarity, and to that extent it's good. But I hate the idea that it's almost like again, I go back to my baseball metaphor, where one person is called out at second base, and we're going to say, anybody slides into second base now is out.
yeah.
It's not that. It's not quite that. Okay, but it's certainly some clarity.
Yeah, and it's on, and to bring this to, and I know when we run the FLSA class that we run together, we always end on the final afternoon and we discuss some trends at the Supreme Court. And obviously this wasn't the
Oh, yeah.
Supreme Court, but we
Right.
discuss trends at the Supreme Court, and it's a maybe 5 minutes at the end, just kind of to, and you and I predicted this back in 2018. There was a case
Mhm.
before the Supreme Court where the majority of the justices basically said, listen, we have since 1938 or whatever the year was that the case was, okay, the first case that came out was they look at exemptions, FLSA exemptions, and they, with the terminology they use is they're narrowly construed against the employer.
Mhm.
And that's something that has for the last 80 years, 70 or 75 years at least, that the Supreme Court and all the courts going down the line have always said, listen, if you want to prove an exemption, such as an executive exemption, as an employer, you have the burden of proving it. That's number one. And number two, it's narrowly construed against you. So you really have to check all the boxes. There's no such thing as, they're kind of exempt. You have to show that they are truly exempt. Supreme Court threw that out the window.
Yeah,
Just,
in
just basically
2018.
said
Yeah.
2018. And
Yeah.
this is the first case that I'm aware of that's going to a circuit court, FLSA related,
Mhm.
that was filed after, you know what I mean? It was filed after
Oh,
that
did the
Supreme
court
Court
mention
decision.
that in the
And
decision?
now,
Did the court?
absolutely.
Oh,
Yeah, well,
wow.
in the
Oh,
decision, hold on a second. I know I've read so many things, Kurt.
yeah.
No, but
Okay.
because they were discussing the evidentiary standard,
Mhm.
because now it's and this is a little
Yeah.
bit above where some folks might be, but
Yeah.
the
Yeah, but it's certainly,
I'd have to
when
look to
this,
see. It was definitely part of the equation, whether or not
yeah,
it made
when,
its way into the decision. But the judge
Mhm.
during the back and forth of the oral arguments at the district court level, absolutely, it was well understood that this
was
is no
the,
longer narrowly construed.
right, the Supreme Court has sort of sent the message out that, that they are looking at the FLSA a lot sharper, with more of a pro management um, overview. And I
Sure.
think that certainly that may have played a role in the
And
decision going the way it did.
it's ironic because in the rationale that's utilized, and it's not a bad rationale when you think about it, is if it's in the text of the FLSA,
Mhm.
then we should do it. If somewhere in the text of the FLSA it's stated that these exemptions should be narrowly construed against the employer, then your textualists would say, and like that's who kind of had those folks wrote the decision in
Mhm.
2018 in the Supreme Court. If it stated that in the FLSA, then absolutely that's what you do. But if
Mhm.
it doesn't state it in the FLSA, then there's really no need to take that approach with that scrutiny, with that
Yeah.
heightened scrutiny on the exceptions. And the irony is, if you look at the first responder regs, they very clearly state that if you're a first responder, you're entitled to overtime regardless of any of your rank or pay level.
Yeah.
So that to me seems pretty clear cut in the regulation.
Well, we are strict constructionists when we want to be, and we're not when
Exactly.
we
That's,
don't feel
hey,
like it. And
and we do the same thing. So
yeah,
it's
I
not,
know, I
it's
know.
that's
My dog does it. Everybody does it.
exactly, exactly. So you
Um,
do have, and again, I think
uh,
from a, and any attorneys that are out there or folks that are watching this from the 30,000 foot view, like sometimes we have to,
mhm.
take a step out of the details and see the big
Yeah,
picture. There's no doubt that that 2018 decision by the Supreme Court, put
yeah,
tip the finger on the scale to a bit here. Maybe
yeah,
not totally, but there's no
mhm,
doubt that that was part of it.
yeah. Well, Bill, thank you for bringing me up and everybody else up on the details of this decision. And again, we've been doing the FLSA class. We're going next year will be in our sixth year of delivering it. And you look at the evolution of some of the things that we've been talking about, and I think it's really gratifying to me. I handle all the registration material, as folks have been through the class know, and it's gratifying to me to see folks coming back again, folks who were in the class like 4 or 5 years ago coming back, because things change, and this is a
Yeah.
perfect example where things change, and it's you know, it's a lot of material, and if a lot of what we said, I kind of, there's a couple points I was going to stop you and just say, well, explain this, explain that, but you know, there's only so much you can do. We spend a lot of time building people's knowledge up about the difference between what the Department of Labor does, what Congress does. The FLSA was not written by the Department of Labor; it's written by Congress, and the Department of Labor has a role that Congress assigned them, and they come out with regulations, and then we have opinion letters, and uh, you know, there's a lot of things. We build the knowledge up so that what we're talking about here makes sense, that we're all speaking the same language, and you
I
know,
remember
so
when we were putting the class together, I remember one of the big issues at the time was your healthcare buyback money. If you
oh
gave
yeah,
somebody
yeah,
cash in lieu of taking health benefits,
yeah,
that was the big issue back in, I guess, what was that, 2014,
yeah,
2015? That was the big
yeah,
issue was, oh my gosh, you gotta, you have to put that in the regular rate. And
yeah,
now it's old school.
yeah,
That's a given, now we're moved on to other things. So you're absolutely
yeah.
right.
Things have evolved, you know. So
Yeah.
all right, well, let's see. We've been going for, I don't know, half hour or so, a little over a half hour. So I don't know. You have anything else that you wanna add to wrap up?
No, I
Well,
just,
go ahead.
there is a lawsuit percolating down in the, I forget which county it is. It's down in Florida where captains assigned to engine companies, a lot of companies were being treated as exempt. And that
Mhm,
lawsuit's kind of moving its way through the process down there in the 11th Circuit, down in the southeast portion of the country.
mhm.
So it'd be interesting to see uh, if at all. And obviously here in the Fourth Circuit, pretty solidly, they've kind of drawn the line here, where you have folks that are assigned to the engines that are, actually handling, hose lines and throwing ladders, et cetera, are covered under the first responder regs and therefore eligible for overtime.
Did they say
Um,
ladders? Did they say
they
ladders or
did,
just
they
hose
did,
lines?
they threw, no, they
Oh,
threw
okay. All
ladders.
right. I thought I
Yeah,
thought maybe
I
there was
know.
a no, no, I'm only kidding.
No,
I'm an old
but
engine guy, so it's,
that's
mhm.
it'll be interesting to see, and I'm sure that the attorneys down there in whatever county that is, those the attorneys representing that county are going to be scrutinizing this decision for anything they can apply, to bring it over in there. So we'll keep an eyes on it and see what develops.
Yeah. Yeah, good stuff. So, all right. Well, that's going to wrap it up for another edition. We'll include copies of both of the decisions, and I'll see if I can get a copy. I think we got a copy of the first responder regs. I'll try to, at least I'll put a link to the first responder regs if I can't get that added. And that's going to wrap it up for another edition of Fire Law.